So I'm going to try something new here. I'm looking at historic complaints that we worked on, going back to when we started out in 2014. The first case I'm actually going to look at is a complaint actually about data protection and about libel rather than homelessness law. But essentially, the idea is that if I kind of run through like an outline of it, hopefully you'll kind of get an idea of how complaints can kind of how they generally progress, and hopefully there'll be some stuff in here which kind of helps kind of give you a few pointers as to how you make a good complaint, what can go wrong, what you do if the outcome's not going well, all that kind of stuff. So if I just, in fact, I'll give you a bit of background. So this guy, we'll call him Matt. It's not his real name. And basically, Matt was a guy that John and I had known for a long time. We worked in the homeless sector in sort of night shelters and day centre settings. And Matt had been homeless pretty much his whole entire adult life. So I don't remember him ever having, his own home. And he struggled with drug and alcohol issues, sort of what I guess would be described as low-level mental health issues. He was same age as me, really tough guy, but really likable. Really kind of, he's not the sort of guy you wouldn't mess around with. But as I say, decent and reasonable. And basically, the kind of case starts. In fact, I'll give you a bit of background how it actually worked. He was accessing the day centre, which at the time was run by an organisation called Beachar. And Beachar, to get someone into a hostel, you had to kind of use this online system, which was run by Capita. And you basically fill in the person's details, all their kind of so-called support need kind of type tick box things, and it would tell you, it would basically send that application off to the hostels that were deemed to be relevant. So, and at the time there were hostels. Some hostels wouldn't take particular age groups. Some hostels would be for particular issues. Some would be kind of assessed as low support need hostels. Some would be, I think there were technically some high support need hostels. And so that was kind of how that's how it worked. And I don't think it's very unusual. I think that's a fairly typical system that was used by councils to manage hostel applications. It just sort of saved money on individual workers kind of processing it all. So Matt had accessed the day centre. The day centre worker had basically filled in the Capita online system. It pinged off to several hostels, and one of the hostels, which I'm not going to name, there's no reason why I can't name it, but I'm gonna not name it. It's an organisation you might have heard of. It's got a bit of a national presence at some level. So if you work in the homeless sector, you might have come across these guys, but they're not a particularly bad organisation. But this kind of practice, as you'll see, probably does beg some questions about the way hostels work and the way the homeless sector works. So as I say, the hostel application had gone off. The hostel had received it. I'll call it the hostel or the trust throughout. And basically, the email we got back, and apologies for kind of the quality of this is when we had like terrible IT equipment, so it's kind of all printed out on a terrible printer and then sort of scanned back in and whatever. So this was basically the email. So this was like, hi, this was addressed to the worker at the day centre. Many thanks for the referral received. I regret to inform you that we're no longer able to process Matt's referral further. Following the result of a Bedfordshire Police National Computer Check, the hostel are unable to accept clients who have been convicted of a Schedule 1 offence, in brackets, sexual arson and violent offences. Unfortunately, Matt has a previous Schedule 1 conviction. Please do not hesitate to contact me if you wish to discuss this matter further. Regards, then the worker's name. So, as I say, and just to kind of give you some background as well, at this time I was working for a drug and alcohol service, and I know that this was not the only person this was done to. So essentially, Matt was not a Schedule 1 offender. So a Schedule 1 offender refers to a group of offences against children, involving kind of abuse of various kinds, very serious offences, and they are offences which, if you are known to be a Schedule 1 offender using homeless services, it can often be a real kind of problem, because you'll often get attacked, and you're at risk of kind of assault and stuff from other people using hostels. It's a very kind of live issue within the homeless sector, because a lot of people have been sexually abused, during their own lives. So there's kind of a lot of emotional stuff that goes with that. So as I say, this was not a one-off. The reason I know that is one of my clients at the drug and alcohol service had the same response And unfortunately, he left town before I was able to do anything about it. So, in one sense, the wording this all arose from the workers' misunderstanding of what a Schedule 1 offence was, and just a whole load of shoddy, just organisational policies, basically, which we'll kind of come to. So, as I say, this is the kind of first thing. We know Matt. Both John and I know Matt, and we're like, we don't think he's a Schedule 1 offender. We've never heard of that. He doesn't kind of, there's no indication that he is. And so we kind of said to Matt, look, you've been rejected. They say you're a Schedule 1 offender. You've been convicted of a Schedule 1 offence. He's like, no. I think his offences were kind of literally pretty low level stuff, like cannabis possession, some stupid like kind of criminal damage he did when he was coming back from a festival or something. I don't know, but that was it. And the reason, and so we wanted to be sure. So he requested a copy of his criminal record from the police or from whatever the sector deals with that, and confirmed that he'd never been convicted of anything like a Schedule 1 offence. So we were like, okay, what do we do? Let's complain. This is stuff. Well, let's raise it with the hostel. We didn't actually kind of call it a complaint in the first instance. So I rattled off this kind of email or letter or whatever. It was done in a letter, actually. As I say, this was like literally, I don't think we even had kind of a functioning IT system at the time. It's very early on when we were starting out. And basically, so this was the content of my letter. Matt seems to be a little bit bewildered with the content of this communication, and has requested that we ask the following: how was the hostel able to access Bedfordshire Police PNC without Matt's informed consent? That was number one. Number two, what are your policies and procedures regarding the access of applicants' criminal history? 3, how do you use this information, i.e. who sees it, how do you store it, how do you dispose of it, and what framework do you use to reject an application based on this information? 4, to which specific offence on his criminal record are you associating with Schedule 1? And number 5, are you certain that you may have access to correct individual's criminal history, as he seems to have spelt his name wrong 3 times? And I didn't really mean that was not a sarcastic remark. They, within the stuff we'd seen, they'd kind of spelt his name, and we just thought maybe there's been a bit of confusion. I look forward to your response. If we have had no response within 2 weeks, we may consider using your complaints procedure to ensure a response. And again, we could have just piled in with a stage 1 complaint straight away. Maybe we should have anyway. But essentially, that is not, in our opinion, a shitty kind of email. That's given the circumstances, we've got a potential liable issue that in a sense is kind of potentially led to him not getting housed. So I'll come back to that later. This was a serious issue. So that's what we're kind of asking. And it kind of, at the time, I'd spent quite a lot of time reading up on data protection law. So that's kind of why I'm kind of asking some of these things. Essentially, for a hostel to make, to access criminal record stuff for someone, they would need that person's informed consent, and there was nothing within the Capita system which would suggest that's what happened. So basically, Matt provided his information to the day centre worker in good faith. The day centre worker then sent that off in good faith, and all of a sudden this hostel is kind of requesting information from Bedfordshire Police. As an aside, there were legal questions to be answered, let's say, by both the council because they were managing the system, and Bedfordshire Police because they've got no basis to provide this information. But as I say, we're very small, just me and John, part-time, but in our spare time, effectively, we weren't getting paid at this point. So we're just like, okay, let's kind of just focus on the hostel. Just trying to think if there's anything else that's kind of the other kind of question here is how on what basis do they use this information? Because the information, if we actually go back to what the police is saying, there's actually very little kind of detail there to actually make a risk assessment anyway. Lots of people have kind of criminal offences, historic criminal offences, and they don't pose any risk to anyone. So it's kind of a question is, okay, how is that hostel using that information to work out if that person's suitable for the hostel or not? So yeah, but as it turned out, the Capita system itself, there was obviously a kind of a glitch with it, because as it turned out that Matt wasn't eligible for this hostel. Because I'm trying to keep it reasonably anonymous, let's say it was because of his age. So there are certain hostels that kind of only deal with certain age groups, and let's just say he just fell outside that age. There is a little bit more to it than that, but that's what I'll kind of say at this point. That's what you need to know to make sense of this. And this is kind of why I'm starting off with this complaint, because it's a perfect example of the archetypal complaint process, how it kind of proceeds. So You have a problem that's serious enough to complain about. You contact the organisation. You essentially complain. It wasn't a formal complaint, but it was a complaint. And what we tend to see is the first stage response will be pretty shitty, pretty, how dare you even kind of complain about anything? Your tone is horrible and stuff like that. So I kind of read their response. This is a first stage response. Dear Mike, many thanks for your hand-delivered letter dated 2014. It is unfortunate that Matt was not fully aware of how the referral process works, and this should have been explained to him by the referring agency, Prevent Day Centre. Now, again, that is not a good way to start the letter off. There was nothing within the small print of the capital referral form that PNC checks were going to be done. And also, as I say, the kind of the referral made to the day center, the hostel was kind of automatic. It wasn't the day center's error. So the day center had nothing to be kind of criticised about here. After screening, this is where it gets interesting. This is where you kind of think, okay, if you're responding to a complaint, guys, don't be a douchebag and kind of incriminate yourself. After screening the referral for Matt, we noted that he did not meet our criteria due to the referral information provided. So essentially, he falls outside the age group, let's just say it like that. However, before exploring the referral further, we requested a PNC check from Bedfordshire Police. So essentially what they're saying is that we already know he's not eligible. So there's, at that point, you just should stop doing it and get back to the referrer and say this person's not eligible, end of. But they continued anyway for some reason, and they requested a police national computer check from Bedfordshire Police. So again, there is literally no lawful basis to a request it, or for Beds Police to provide it. There's no consent given. There's no information given to Matt to kind of explain this is what's going to happen. Goes on to say, due to the nature of the setting, all referrals to the hostel are stringently screened. The CAPTA system, whereby we receive all referrals, will disclose whether the person being refused has criminal convictions. The PNC check is conducted with all referrals due to the nature of the setting and our duty to safeguard vulnerable adults. Now, this is nonsense. You can't process more data than you need to. That's kind of absolute underlying principle of the Data Protection Act, even more so now, but it still was with the 1998 Act. So basically, you can't. It's essentially, this kind of goes back to this kind of like blanket thing. It's the same with a referral for a job application. You don't request the reference until the person's basically been, shortly or kind of given the role, because what you don't do is with everyone applying for a job interview, you don't get a reference for all of them because you're going to get all sorts of information which you actually don't need. You basically screen out everyone who is not the best person for the role, and then you get the reference. It's the same kind of thing here. What they should be doing is checking from the information what they've got actually tallies up with their their criteria, making sure that Matt was a good candidate for their hostel. And if he kind of passes all those checks, and probably only if you've got some uncertainty about the criminal offending history, you might then, with his consent, do a PNC check. I'm not even sure why you do that, because he declared the offences on the CAPTA referral form itself. So I don't really know why that you need to do that. But anyway, so basically it goes on to say, our allocation policy advises of the following. In assessing an application, support and risk factors will be taken into account, fair enough, and needs and risk assessment will be completed by a hostel employee with each applicant, and where appropriate, in consultation with the appropriate referral agency or representative prior to the letting being made. Information may be sought from appropriate agencies working with the applicant or elsewhere as required. This will include a PNC check. So as I say, this is a problem. This kind of comes out late when the ICO got involved. When we complete a PNC check, we merely send the applicant's full name and date of birth to Bedfordshire Police requesting the check. We generally receive the following response from the police. The person is or is not known to have been convicted of a sexual, arson or violent offence, including the use of a weapon. Now, technically one of the offences Matt had been convicted of was violent. I think there's like a conviction for a fray in there. It's a relative, as violent offences go, it's down the bottom of that kind of pecking order. So essentially, this is what I mean. Like, what good would that information do anyway? So okay, they've been convicted of one of these types of offences. So what if it was a fray? How are you just going to automatically decline people from the hostel for an offence that might have been carried out sort of 15 years before and might actually be spent? It's just not well thought through. And then it goes on to say the actual offences are not disclosed to us. In answer to your question, I have reviewed the PNC check request and can assure that Matt's name was spelled correctly as stated on the referral. So as I say, there's more problems which we'll come back to. And then, as I say, you kind of start getting this shitty sort of tone come back from the, how sort of, why are you complaining to a sort of thing. So at this stage, I feel compelled to address the tone of your letter, which I found inappropriate in parts. I found the following statement wholly unnecessary. If we had no response within 2 weeks, we may consider using a complaints procedure to ensure a response. Now, as I say, that is not wholly unnecessary. In one sense, we were saying we're going to do this informally, but if you don't respond to us, we will take it down the formal route. In one sense, that's a nice thing to do. We could have just gone straight in with a stage 1 complaint. So, I would profoundly argue, really argue with the, that kind of comment. And probably just an aside, at the time, my mental health was terrible. I'd just been through some very difficult times, let's say. I was very, very fragile. And I think, had it not been for John kind of saying, this is just a wanky response, don't worry about it, Mike, I would have probably given up there. So there's no, in one sense, it's easy to kind of look at all this stuff historically and sort of say, well, this is how it all worked. But at the time, we were a tiny organisation. We were complaining about big organisations in the town. I was feeling very, very vulnerable. Very, very kind of, we really felt that if we put a foot wrong, if we got anything wrong at all, we were going to get shut down, and this was going to be the end of of the charity. So really kind of lost a lot of sleep over it, even though it might seem really pathetic. That's kind of what my state of mind was. So that's kind of how that went. So that was the first stage response. And as I say, it's a fairly typical one. The first time you complain to an organisation, you will often kind of get that, how dare you complain to us? Who the hell are you sort of response. Even with councils, not always with councils, they tend to have a bit more experience with dealing with complaints, but that's on par for the course. Key thing is don't give up. And I guess I'd say on that, if you're going to do this kind of stuff, make sure you've got some good people around you. As I say, without John's kind of objective, no nonsense kind of look at this and encouragement to kind of go with it, I would have given up probably, or certainly kind of, I don't know, probably not been as effective as it ended up being. So basically, we essentially we then made a formal complaint. I don't think I've got that file up here, but basically, so we essentially said exactly the same thing again, but did it as a kind of a first stage formal complaint. And basically, we then get again a very typical sort of second stage response from the hostel, where the organisation accepts that it's ballsed up, but it doesn't. It doesn't kind of really go very far. It certainly doesn't kind of start offering compensation or anything like that. It just starts going through it. So basically, I can't even remember what's been blanked out here. Matt's application should have been rejected for the reason that, in one sense, that he didn't meet the eligibility criteria, and we accept that there was no need for a PNC check. So that's the first one. So they're accepting they should never have done a PNC check. That was unnecessary data processing, and in one sense, the police should never have given it. It appears, so second bullet point, it appears that a PNC check was requested without specific prior consent having been received directly from the applicant. Our applications policy requires consent prior to a PNC check being carried out, and we've now put in place measures to ensure this oversight does not happen again in future. So the third bullet point, the PNC check we received state that your client is known to have been convicted of a sexual assault or violent offence, including use of a weapon. From discussion with the police, the offence disclosed in the PNC may or may not have been a Schedule 1 offence. Therefore, the assumption made by us may not have been correct. It wasn't correct. This is really annoying. By this stage, we'd shown them the criminal history and everything. There was the criminal record. There was no Schedule 1 offence on there. But this kind of language kind of remains throughout the rest of this process. So, he may not be a Schedule 1 offender. No, he definitely wasn't a Schedule 1 offender. You guys should actually just have the decency to accept that you've really stuffed up. But they have kind of said, the assumption should have been made. Fourth bullet point, there appears to be some misunderstanding over the definition of Schedule 1 offences. There was nothing in the information received from the PNC check which suggested that the applicant had been convicted of an offence where the victim was a child. We will clarify the definition in our policies, and we will ensure staff receive training in this area to avoid future misunderstanding. So this is a mixture of the individual staff member processing it, not understanding essentially what they're talking about, and so this was not in any way malicious. But the fact is, the organisation had just simply got terrible policies and training in place. So And as I say, this was not a one-off case. There will be people probably still in Bedford, which somewhere on their record says they're a scheduled offender when they're definitely not. We just don't know where they are. So I guess if you're receiving kind of information like this, it's always good to kind of check where the information's come from, because it may well be spurious, even if it's coming from a well-known organisation. And then I think this is the last one here. The results of the P&C check were circulated by email without prior consent of the applicant, which is contrary to our data protection policy. However, the circulation of this email was limited to our referral team and the referral agent. Our applications policy does state that we will notify the reasons for rejecting an application system. Rejecting an application. However, in this particular case, the reason would have been stated on the CAPTA system and would not need to communicate it directly. So I agree with them here. In one sense, part of the complaint was that they shared this information with people who didn't need to know, but it was only a small number, so it wasn't like they kind of broadcast it to the world. But I guess it's important to remember that that at the time there were multi-agency meetings with all these kind of partner agencies kind of gathering together. It is not in any way implausible that had one of those hostile workers been in that meeting and this Matt was discussed in the meeting, that he would have piped, the worker might have piped up and said, oh, this person's a scheduled offender. And then all of a sudden, the whole sector thinks he is. And that's the reason that they'll often reject everyone from their hostile projects. So in one sense, although it didn't in this case, it could have easily led to Matt being really screwed over for his housing options. So just to kind of labour the point, the hostel sector kind of, and the charity sector kind of goes and sort of talks about how much good it does. In Matt's case, he'd approached a hostel, and in every single way possible, he was worse off for doing so. They didn't benefit him in a single way. So it's kind of I think it's worth kind of challenging those assumptions that charities are always good, because they're not. They might mean well, but they can often, because of incompetency and whatever and poor policies and stuff, they can do a lot of harm. So it goes on to say, we've reported this incident to the ICO, which is something we'd asked them to do. We have also drawn up a detailed plan of action following the investigation, which will be sent to the manager and will be followed up by our Director of Operations. Thank you for bringing this matter to our attention. So, as I say, we'd made the same complaint like directly to the hostel, and then this obviously went to kind of head office or something. And the tone of the letter is very, very different. And this is one of the more, in one sense, although they're refusing to give compensation at this stage, they are putting their hands up to it, and they are, in all fairness to them, they are kind of sorting things out and improving things. And a lot more of that stuff came when the ICO got involved. But as I say, if I'd have left it at stage one, nothing would have, it would have just kind of been left and nothing would have changed. So I think because I was in a very paranoid state of mind, certainly. I don't know, what I'm thinking was, we basically, I wasn't in a paranoid state, but I tell a lie. The reason we went to the ICO was in order to get compensation for Matt and take it to the small claims court. We basically needed to take it to the regulatory body first, which was the ICO. So we basically complained to the ICO. Again, the same complaint, same thing I've kind of covered already. So the ICO then investigated it for a few months. So by this stage, we're probably sort of 8 or 10 months after the actual discovery that he'd been libelled. The ICO response was this: thank you for our email today regarding Matt's concerns about the handling of his personal data by the trust. To summarise, Mr. Matt's concerns, these relate to an application for housing made by him to the trust. During the course of the application, the trust conducted a P&C check without Matt's explicit consent and via an unencrypted email. We confirm that the trust has reported this breach to us prior to Matt raising his concern. The Data Protection Act contains 8 principles of good information handling that organisations called data controllers should follow. This particular issue is relevant to the Data Protection Act as it relates to the 1st, 3rd, 4th and 7th data protection principles. So they've done pretty well here. They managed to get half of the principles kind of to be flagged. Let me just see if I'm going to go through this in by word. I probably will do, because this is information you need to know. If you're working in the sector, this is good stuff. And although this is the previous Data Protection Act, the principle is almost identical now. So if, the same things ring true now. It might just be a different principle number now. So basically, Principle 1 states personal data shall be processed fairly and lawfully, and in particular, shall not be processed unless at least one of the conditions in Schedule 2 is met. And in the case of sensitive personal data, which is this, because it's criminal offending history, at least one of the conditions in Schedule 3 is also met. So this is basically, in this case, explicit informed consent from Matt would have made this processing legal, but they didn't have consent. There are essentially two parts of this first principle. Any processing of personal data must be fair and lawful. In terms of fairness, in the broadest sense, this requires that personal data should not be processed in a manner which could be considered outside the area of the reasonable expectations of the individual. So when Matt provided his information to this referral system, he didn't know that the P&C check was going to be conducted, and he should have. In one sense, that kind of idea of fairness, you can't give your information over and then it's used in a different way from what you're expecting it to be used for. So, what the capture system should have done is it should have explained to applicants in detail how things are going to be used, so they can actually make an informed decision. If they're going to be asked for consent. It goes on, the data controller must also have a legitimate basis for the processing. Where the processing includes personal data, a condition for the Schedule 2 the DPA must be met. I've kind of said this stuff. So basically, it has to be explicit consent in this case. Principle 3 states personal data must be adequate, relevant, and not excessive in relation to the purpose or purposes for which they're processed. Principle 4 states personal data shall be accurate and, where necessary, kept up to date. And Principle 7 states appropriate technical and organisational measures shall be taken against unauthorised or unlawful processing of personal data and against accidental loss or destruction of or damage to personal data. So again, this is it's just been kind of tightened up a little bit with the new law, but it's basically the same law as it was then. Whilst not an exhaustive list, it appears likely that the trust has breached the above principles on the following grounds. So lack of consent sought from Matt to make the P&C check, which is breach of principle 1. Unnecessary request for a P&C check and disclosure of sensitive personal data to Mr. Blogg's agent, Matt's agent, which was the day centre worker. Matt disputes that he has a Schedule 1 offence and the information held by the trust is potentially inaccurate. As I say, this is where I'm saying, they should have just outright said he wasn't a Schedule 1 offender, but this kind of uncertainty then followed him around. And then lack of training and awareness of procedures, so that's a breach of Principle 7. In this case specifically, a number of these breaches appear to be more of an issue around the behaviour of an employee in question. Crucially, in the case of Matt's, I don't know what's the words here. In the case of Mr. Bloggs, it was unnecessary to have requested a P&C check in the first place, as he was not eligible for the housing scheme, so wouldn't have been accepted irrespective of the results of the P&C. Similarly, the potential inaccuracy around the Schedule 1 offence appears to have just been assumed by the employee. Though human error is involved here, there were considerable failings in the trust compliance prior to the incident, and there are ongoing concerns about the trust's use of P&C checks. At the time, the trust had some relevant policies in this area covering the processing involved, but these were not consistent with each other about the P&C checks, about when the P&C checks were necessary, and there was no formal DPA training in order to underpin these. We confirm that we are currently working with the trust to improve its information handling practices, and the trust has taken remedial action to review current policies, to introduce specific guidance on the P&C checks and providing DPA training to all staff. However, there may be scope for an undertaking to hold them to carrying out things which haven't been done yet, such as introducing mandatory refresher training, as well as reviewing the situations in which P&C checks are carried out so that these requests are proportionate. It may well be that this matter may be resolved informally. A final decision as to whether formal regulatory action against the trust is yet to be taken. On the basis that our enforcement team are continuing to work with the trust, it is not necessary for me to take further action in relation to Matt's concern. I will therefore now close my file on this matter. I hope this information is of assistance to you, but should you require further in the future, I'm sure that there's a typo there, please contact me quoting the above case reference number. Thank you for bringing this matter to your attention. So essentially, and I've made a few data breach complaints now, and essentially this is what the individual find out. So there's essentially obviously a regulatory team within the ICO, which then kind of do specific work with the organisation, but the details of that won't be passed on to the individual that's raised the complaint, because in one sense they would deem that the information within these letters, this letter is enough. So we then had, so as I say, we're probably like 10 months after the actual incident happened now, so we've now got a letter from the ICO. We've basically got the organisation has accepted it's done wrong. The ICO is kind of going into detail about how it's done wrong. we then start the small claims process. So before you go to small claims court, and as I say, we kind of learned this as we went. One of the reasons we call Just Us is because we just got Google. It's just us and Google, basically. So we don't, we kind of find stuff out as we go. But the small claims court requires that you try and resolve things between you and the other party without going to court. So this is the letter that I presumably sent. It's a long time ago now, so I guess what it is. So following the events around the trust handling of Matt's sensitive personal data in the autumn of 2014, it should say, and the incorrect assertion that he was a Schedule 1 offender, I wish to request compensation from Matt on his behalf. We have liaised with the Information Commissioner and received a letter from them, dated whatever it was, summarising their concerns about about the trust handling of Matt's data. For future videos, by the way, I'm just going to sort out the kind of the anonymisation here so it actually reads better. Having discussed the situation extensively with Matt and taken advice from the courts, I wish to support him to make a claim for £5,000 compensation for the substantial distress caused to him following the trust's assertion that he was a Schedule 1 offender and the mishandling of his sensitive personal data. In line with the advice we've received from the courts, we're writing to you to provide you with an opportunity to reach an agreement with Mr. Bloggs without having to take the case to court. I'm aware that the Court of Appeal has recently ruled that a claimant can be awarded compensation for distress alone, and there is no need for there to be financial loss to the claimants. That was quite an important case, actually. I forgot which one it was now. I think it was to do with Google, but anyway. I am also aware that in another case, Cliff v. Slough, which was the case which I kind of heard about, which kind of made me completely change my working practices, by the way, because up until then I was in this working in the sector and had no understanding of data protection law whatsoever. But the Cliff v. Slough Borough Council case is a really interesting one. Miss Cliff was awarded £12,000 compensation for the mishandling of her data where there was no issue of the information actually being incorrect. This should underline the importance of organisations handling data properly. So I'll kind of hold you in suspense for a minute. So we sent the letter off. There's a little bit to and fro in. I can't remember exactly what we're saying, but nothing substantial. And I remember I just picked my boy up from school and I was in the kind of local park and I got a call from a solicitor. Bearing in mind, as I say, I'm not mentally very well at the time. I'm really kind of, really anxious and paranoid. And start kind of talking about, compensation in this park. Kind of like I went off to a little kind of secluded spot. And essentially, first of all, the solicitor had been obviously kind of employed by the hostel, and I'll come back to why I was particularly annoyed about this. But essentially, the solicitor's job is to work in the interests of the hostel and therefore try and absolutely minimise the amount of compensation given. So I think initially they said, well, there's no compensation that needs to be given. I then wrote to him. This is where I learned a lot of stuff. This is why complaining is a really kind of you will have to learn a lot of stuff to kind of do it well. So I kind of went off and did a lot of case law, looking at a lot of data protection case law. So there's one involving the supermodel, I've forgotten the name now, and Daily Mirror, and there's kind of some other cases as well, which I kind of like piece together and say, okay, you've got a principle here, kind of led there to £1,000 compensation. This thing over here led to the 750. The amounts back then were much less than they are now. So data breach things now, you're looking at thousands or tens of thousands, whereas back then you were looking at sort of, hundreds. So it was kind of very much a developing kind of area of compensation. And, again, so we kind of to and fro, and then they kind of offered 750, went and spoke to Matt. And we were kind of saying to him, we think you could get a lot more. So he said, yeah, okay, go back and try and get some more. So I kind of went back. I kind of just having to argue with all the stuff the solicitor was saying, your logic's shit. Basically, you're kind of clearly sort of underplaying a lot of this stuff and kind of downplaying the seriousness of it. They then offered £2,000. Went back to Matt, said, probably Matt, you know what, we can probably still get a lot more. But in the circumstances at the time, this had been dragging on. That was well over a year. By then, it was like sort of 15 months. It was just, I think it was coming up to Christmas, and he was like, you know what, I'll take $2,000. So that's kind of what we did. So we went, this is kind of the final settlement kind of copy. So this settlement agreement is not, this is the wording you often get. I don't understand it because I'm not a lawyer, but basically settlement claims should pay £2,000 to the account of Matt on or before Monday, whatever day it was. The settlement sum represents full and final settlement of the claims. Now, I've never paid for a lawyer before, but my guess is that I would imagine they spent probably a similar amount of money on the solicitor, because I spent quite a lot of hours arguing with him. And so, maybe I don't know, maybe I'm wrong, but I think it's likely they would have spent a similar amount on that solicitor. So going back to that kind of initial, I think we asked for £5,000 initially. It was a bit like not quite sure how much it's going to be, to be honest, but that seems to be a fair amount. They probably ended up spending £5,000 on the issue or thereabouts, but half of it went down the neck of a solicitor rather than the actual client. So again, it seems to be kind of the way things work. But when you've got charities using solicitors to kind of act really kind of in a Machiavellian way in order to protect the interests of the hostel, I think there are serious questions about the ethics of that hostel. I think the bottom line is if the hostel is working with vulnerable people. In this case, it had kind of failed to even do basic things to kind of safeguard that, to safeguard Matt's human rights effectively when it was a human rights issue. A decent organisation could have just held their hands up and said, yeah, we'll pay the £5,000. They should, if they were competent and if they were fair, that would have been, I think, the right thing to do. But they didn't, and that's kind of, this is what happens really. But as I say, yeah, that's as I say, that's an example. I mean, in one sense, kind of just did a quick summary of it all. What was a good things? Well, first of all, we managed to kind of make sure that Matt was not kind of regarded as a Schedule 1 offender, because as I say, that information does get out and it does get around. We also got the organisation to drastically improve their policies and stuff, and no data protection. This is what it's really difficult to explain data protection because everyone rolls their eyes when they hear data protection, and it's just this thing which is annoying. Data protection law is so amazing because it makes organisations respect the humanity of the people it's working with. It makes them, you can't follow data protection law without respecting the individual's wishes and giving people choice over how their information is used. You can almost make an organisation pursue a person-centered approach just by making them follow data protection law. So this is why, it sounds really boring and pernickety. This stuff isn't. If they followed data protection law, essentially his rights would have been upheld throughout, and he would have been given real choice. And and giving people choice when they're homeless is a really important thing because they don't have a lot of choices available to them. So maximising those choices, that's a good way of doing. So, as I say, in one sense, the organisation improved their kind of the way they presumably treated everyone, which is a good thing. And as I say, I imagine that this kind of had ripple effects, and other projects run by this organisation would have also improved as well. So just making this complaint, as I say, we weren't getting paid at the time, so it cost us nothing. Well, it cost us £10 for a subject access request that we sent to the hostel, which I forgot to say actually. Right early on in the process, we made a subject access request to the organisation, which at the time cost £10. It's now free, and we were kind of able to get some more information about it. But yeah, so it cost us £10. It cost the charity £5,000 directly, probably, but also you got the staff, time probably running around. But it got them in the process to improve things. And it kind of, it for him, for Matt, it was the first time he'd ever seen justice. I would, seen anyone sort of fighting for him. I'd say, obviously a lot of people would be nice to him in the sector, but actually, for people to stand around him and say, actually, you've been libelled here, we're going to stand up for you here, and kind of, and do something good. I think meant something to him. So I think that's kind of part and parcel of what we're doing when we do fight for people. Is we're actually saying, we're with you. You're part of society. We want, we're fighting for you and stuff. It's a good thing to do. So, if you've got any questions about this, feel free to put them in the comments. The usual YouTube spiel. Subscribe to our channel. Like us on Facebook. Get in our group Better Homelessness Practice on Facebook, because it's just a really good place to share information. But yeah, as I say, this is going to be first of a lot of these videos I'm probably going to do, because I'm hoping that this is an encouragement for those who are seeing shit things happen in the sector and are thinking, hang on a minute, no one else is going to do anything about this. That was our kind of take. We when we hear professionals say, "Oh, that's outside our remit," I'm a bit like, yeah, if we want to get justice for people who want to end homelessness, we're going to have to do things outside our remit, because there ain't no one else is going to do it. So yeah, hopefully it's an encouragement. Some of the complaints I go through will be ones that didn't have a good outcome. They still sting. There's no doubt about it. In one sense, all through this process, you're kind of putting your reputation on the line, because if it turns out you're wrong about something, you just look like a dick. And no one looks like no one likes looking like a dick. So yeah, and let's face it, I mean, fortunately with this organisation, we don't have to kind of sort of carry, kind of get good, get favour with them anyway. We can kind of do what we do. But obviously, some organisations you're going to be complaining about, you have to go and see them, next Monday, and next Monday you're going to be relying on them doing the right thing to get your client housed. So it can get interesting. But yeah, hope it was useful.